This video is designed to give you some context as you read the Conley decision and to think about this decision as we move forward into the more complicated cases of Twombly and Iqbal. Again, remember what we're talking about right now are pleadings that state claims, and this specific aspect falls underneath the topic of what content needs to be part of the pleading in order to state a claim. Now you remember that we're focusing initially here on complaints, but all pleadings that state claims are going to need to meet these requirements. So while the title of this says the content of the complaint, it's really more of a reference to where we're at in the course right now, but any pleading that states a claim will need to fulfill this content requirement we see in Rule 8a. And as we can recall from our last class, 8a has three basic components to it. The first, that you need a jurisdictional statement. The second, that you need the statement of the claim itself. And the third, that you need demand for relief. We've already started talking a little bit about the second requirement, the short and plain statement of the claim, and realized that this means that the claim actually has to have legal sufficiency and factual sufficiency. We gave a couple examples in our last class of claims that failed to have legal sufficiency. One example was a claim that's not even provided for at law. So for example, the hypothetical in which an individual tries to sue someone for giving them an evil look. The law doesn't allow for recovery from insult due to someone giving you an evil look, so that kind of a claim would be legally insufficient. We also gave the example of someone who pleads facts that, when taken into account with what the law requires, themselves just don't amount to a legal claim. So for example, in the hypothetical in which the individual is suing for an age discrimination claim, and he is not the age of 40, the minimum age requirement to be able to sue for that claim, the claim he's bringing is legally insufficient because even under the facts as stated in the complaint, those facts would not amount to a legal claim. So they're legally insufficient. We also are going to talk a little bit more about factual sufficiency, and that really is where we get into the Twombly and Iqbal debate. In order to understand the context of all of this, we need to spend a moment again reviewing the history of pleadings. Your Erickson book does this with some detail, but just to emphasize some of the highlights. After we moved away from the writ system, we moved into what we called the field code pleading system. Code pleading is highly fact intensive. In other words, an individual, in order to comply with code pleading, needed to plead all the ultimate facts, including who, what, when, where, and how of the claim. And if you didn't specify all the details of the claim, the ultimate facts, then your pleading was deemed to be insufficient and dismissed. The field code pleading is different from the Federal Rules of Civil Procedure. The Federal Rules of Civil Procedure departed from code pleading to take what we call a notice pleading tact. Notice pleading, in a nutshell, is that the goal is that we want to put the defendant on notice of the claims that are going to be brought against him so that he can try and provide an adequate defense. So what does it mean to be put on notice of the claims against you? Well, you have to have some idea of what the legal claim is and what the grounds are for that legal claim according to the person asserting the claim against you. So some of the key issues we have and what's going to cause conflict for the court is really, how should we view this pleading at this point in time and view the allegations in them? Should we really question whether or not what the plaintiff said really happened at this stage in the litigation? And to the extent that we're doing that, how much are we questioned it? So we're going to start that in the context of Conley. To give you sort of a summary of where we're going to go here, there's several important cases that we're going to look at. The one that we have in the materials on notice pleading is Conley. Swierkiewicz is a case that's not in your reading materials, but when you look at other Horn books, you might see it mentioned. And essentially it was, on even barer facts than in Conley, an application and an upholding of the Conley decision. The ones in red are our more recent cases, 2007, 2009, and you can see there's only 5 years between the Swierkiewicz decision and the Twombly decision in 2007. But right at the Twombly decision, we see a change in how the court is going to read cases, and how much they're going to allow our rhetorical question of, should we just take everything the plaintiff says without any question in it, or without any suggestion that we could say this is not likely to have happened or not plausible, to be a new consideration. And so our goal here is to make sure that we understand what Conley did, and then to see which aspects of Conley, Twombly, and Iqbal are having issues with, and which aspects they are not. One common mistake students make is presuming that Twombly and Iqbal completely departed ways with Conley, and that is not true. There are aspects that we will learn from Conley that are still continuing to survive post-Twombly and Iqbal. But Twombly and Iqbal ushered in a new era known as plausibility. All right, so what does Conley tell us? When is a complaint factually sufficient? Well, in Conley, the decision was really about racial discrimination. What you saw here were plaintiffs who were African American employees who were fired or either fired and rehired at a demoted status by a railroad. And they argue that their discharge from their employment was wrongful discharge by the railroad, and that the union that was authorized to protect and bargain for them had acted according to their plan by refusing, in a conspiracy, by refusing to protect their jobs, because the union had a duty to protect all jobs without regard to racial status, and in fact they only advocated for white employees, which required all the African American employees resulted in their losing of their jobs and not getting the promotions that they were otherwise entitled to. So the defendant in this case moved for a motion to dismiss under 12b-6, and we will learn in a few weeks defendants' motions to attack complaints. You can just see it referenced in the case here, but essentially that's what they're arguing. So they're saying this complaint is insufficient. It doesn't state a claim. So the grounds here were really one of factual insufficiency. The court here was looking at whether or not these facts as alleged would be enough to amount a claim. The court decided that the test they would use as to whether or not the complaint stated a claim was whether or not the defendant got fair notice of the claim and its grounds. Because again, remember, the court is emphasizing that the goals of notice pleading is just to give the defendant this adequate notice. And they're going to give us a few more approaches we're going to flesh out in just a second here. So let me just move to that, and we'll go back to the rest of that slide in a second. These are from your worksheet, the questions essentially, and you were asked to try and identify these propositions in your reading of Conley. So let's just talk through them for a second, because I want you to understand what they actually mean. Conley told us, and one of the key aspects of Conley is how they viewed the plaintiff's claims. The allegation you see here, that the second one really, in a ruling on a motion to dismiss, the court should presume the facts alleged in the complaint can be proved true, tells us the posturing of how we're to look at the plaintiff's allegations. So this statement is the court telling us that we assume that everything the plaintiff is telling us about the claim is true. So we're not going to question whether this is the way it happened or not. This is not the phase in the trial that we're to do that. We'll wait later to do that. That's coupled with this last aspect you see in the list, that liberal discovery should be allowed to develop the facts of the case. The idea being here that the time and place to question whether or not these facts are true is going to come later, after we have a chance to discover more about the facts at issue in the case. The other aspects that Conley gives us, and one of the most important ones, is the first one you see noted on your worksheet, the no set of facts quote. The quote from the opinion is that a complaint should not be dismissed for failing to state a claim unless it appears beyond doubt that the plaintiff can prove no set of facts in support of his claim which would entitle to him to relief. And that's a very, very low threshold. The other aspects of the of this decision that you need to focus on are the two middle statements here. First, that general allegations can be used to state a claim, detailed facts are not required. Remembering Conley is telling us that the federal rules of civil procedure departed ways with code pleading, that we don't need detailed facts. If you look at the forms themselves, like Form 11 we've been working with from the class, you can see how sparse the allegations need to actually be. And the court here in Conley is saying that's intentional. So we don't, as a court, need to dismiss the complaint in this case because the facts they state, the railroad workers state, if we presume to be true, are enough clearly to prove a set of facts in which they would be entitled to relief. The goal of pleadings, again, I've mentioned several times, is just to give the defendant notice. So let's turn to the case itself. If you look in paragraph 3, where they're applying this beyond no set of facts, beyond doubt that the plaintiff can prove no set of facts in support of his claim, which would entitle him to relief. The last second to last sentence in the paragraph 3 on page 3 of your worksheet is really where you want to focus in the opinion here. So in paragraph 3 it says here, the complaint alleged in part that petitioners were wrongfully discharged, the African American employees were wrongly discharged by the railroad, and that the union, acting according to plan, refused to protect their jobs. So they basically had their conspiracy of unfair representation. And so they breached their duty they owed to the union members. And it says, refused to protect their jobs as it did those of white employees or to help them with their grievances because they were all Negroes. It says if this allegation was proven, there would be a manifest breach of the union's statutory duty to represent fairly and without hostile discrimination all of the employees in the bargaining unit. So you can see here they say, let's take these as true. You had a duty to represent me in a way that didn't unfairly prejudice me on the basis of race. And you failed to do that because the classifications of people that you helped and people that you protected jobs were based on racial lines. You protect the white employees, you don't protect the African American employees. That's a breach of the duty to act in a fair and non-racially biased way when representing members of the union. So what Conley is telling us is we're not questioning whether that's in fact what the union did. That's not the time and place to do this. We can do this in discovery. The union can come and say, no, in fact, we did represent people fairly. I doubt they will, given what happened here, but that's what they could do. All we're requiring a plaintiff is to establish some facts that, if proved true, would provide for relief, and that we would only dismiss the claim if it appears beyond doubt that there are no set of facts in the claim to support the claim. So in other words, completely missing facts or totally sparse to where if we prove them even to be true, it wouldn't amount to a claim. So what we're going to see with Twombly and Iqbal and the plausibility standard is an additional hurdle. We're not just going to say that we can't, that it appears beyond doubt that the plaintiff could prove no set of facts in support of his claim, but really look a little bit more at the plaintiff's facts and take some issue with them. The questions that I'm going to ask you in class and I'm going to focus on when you look at Twombly and Iqbal is to look at this list, and I want you to see whether or not you think each of these is still in existence, and realize which ones Twombly and Iqbal are now essentially sort of departing from and which ones are still there. So that's the trick to that. Let's roll back here and talk about one policy issue, and that will be it for this video. What do you think about the approach in Conley? Is this fair to the plaintiff? Is it fair to defendants? Well, you could argue it's fair and that plaintiff can plead without having to prove before they go to court because the focus is not on the legal skills in writing a pleading, but really on the merits of the decision. And at this point in time, we really don't have the ability to get more facts because we don't have discovery available to us. So the plaintiff shouldn't be disadvantaged if they're unable, for example, to gain more facts. You know, for example, what specifically the union did in not representing properly all members of the union. So all they need to do is allege the basis they believe the unfairness came from, one of racial discrimination, and that a discovery would be able to merit out whether or not that actually happened. The defendants could argue it's fair in a way that it gives them notice of the claims on the basis for them. Here, the union clearly knows the claim is one under the Railway Labor Act and the collective bargaining agreement, and they know that essentially they're being charged with, or the claim is one of racial discrimination. And they know that there's ability to have other ways to get rid of meritless claims. For example, there's some pretrial procedures that they could use to narrow disputes and facts that we're going to learn a little bit more about as the course proceeds. For example, they could get a more definite statement or move for a more definite statement about a fact or issue that they need to know about. They can move for summary judgment later before we get to trial to get a ruling from the court on the fact that they believe the claim is meritless or baseless. But what the Conley court is telling us that those kinds of processes should happen later, that the court should really not be ruling on those aspects now pre-discovery. And we're going to see a change in that policy to some extent in Twombly and Iqbal. So I hope this was helpful. We're not going to discuss Conley in class any more than to clear up any confusion you have from it. But what I'd like you to do is, now that you understand Conley, to work through the cases in Twombly and Iqbal, especially focusing on these statements you see in your worksheet and deciding which of these is still at play and which of these does Twombly and Iqbal dispel with.